United States Court of Appeals for the Seventh Circuit, U.S. versus Heriberto Carballal Flores. Before we even start, can I ask a question? How many illegal migrant third world invaders named Heriberto Carballal Flores does America really need? In what way is it in America's national interest for us to have Heriberto Carballal Flores as an illegal migrant third world invader of our nation? As we'll see, all he did when he was here was commit crimes. What about the other million, 10 million, 100 million Heriberto Carballal Floreses in America as illegal migrant third world invaders? I want to give them all a trip. I want to give them a trip to the booty. To the booty. All right, decided July 16, 2025, so just a couple days ago. 3-judge panel, of course, Federal Court of Appeals panel. Chicago police arrested Heriberto Carballal Flores after he repeatedly fired his pistol in a city street. A grand jury indicted him for possessing a firearm as an illegal alien in violation of Section 922 of federal law. We, the Court of Appeals, must decide whether that federal law comports with the Second Amendment or whether it's a violation of the Second Amendment for the federal government to say it's unlawful for illegal alien third world migrants to possess guns in the U.S. Carballal Flores was born in Mexico, so why didn't he stay there? His mother brought him to the United States when he was 10 years old. Presumably, yes, he was. He claims now to have the status of a lawful permanent resident, but at all times relevant to this appeal, he was an illegal alien. On the night of June 1st, 2020, so it's been 5 years for this case to get to this point. During a summer of unrest across the country, these would be the riot, looting, and arson being committed by the progressive fascist left. You may remember, Only Black Lives Matters, all that protest, Antifa, remember those? Burning American cities to the ground, which of course have never recovered. A police observation camera captured video of Carballal Flores in Chicago's Little Village neighborhood shooting a pistol 7 times at a passing car. He later tried to shoot at another car, but his firearm jammed. Officers arrested him based on the footage. Carballal Flores justifies the shooting, explaining that he was protecting his community from a perceived threat. He claims to have merely fired warning shots towards individuals he believed looted a neighborhood store. In the government's view, he took to the streets amid the civil unrest and without provocation indiscriminately fired at passing cars. Either way, he does not dispute that he possessed a firearm that night. At the time, he was unlawfully present in the U.S. A grand jury thus indicted him for violating 18 U.S.C. 922, which forbids an alien, an illegal migrant third world invader who is illegally or unlawfully in the United States from possessing a firearm. He moved to dismiss the indictment, claiming or challenging the constitutionality on Second Amendment grounds. The district court denied that argument. The Supreme Court then issued Bruin in 2022, only 3 years ago. It's amazing. There, the court clarified the proper framework courts must apply when analyzing Second Amendment challenges. The test is rooted in the Second Amendment's test. This is the text and history test. Whether there was a history of similar restrictions at the time of the founding or during Reconstruction right after the Civil War, at which point the Second Amendment was applied to the states. Until that time, it was only applicable to the federal government. This court, meaning that this Court of Appeals in the Seventh Circuit, then decided Atkinson v. Garland. Garland at the time, of course, was the Attorney General of the United States. In that case, we offered district courts and parties guidance on how to analyze these 922 cases, which bar felons from possessing firearms. Carballal Flores, seeing an opportunity, his lawyer seeing it, moved to dismiss the indictment once more on this new case law and cited Atkinson for support. He urged the district court to hold Section 922 unconstitutional both on its face and as applied to him. So this whole issue around felons possessing guns, there's a federal law that says if you're a convicted felon, you can't possess a gun. But there's been challenges to that provision because the challenge is, well, was there a similar restriction on gun ownership during the founding? And what the federal courts have been finding is that, well, at the founding, there were restrictions about violent people, unlawfully violent people having arms. And so someone who's convicted of a violent felony, well, that restriction may be constitutional. But there's a lot of felonies in the modern era that are not involving violence. You write a bad check over a certain dollar amount, you may well have committed a felony. You steal a car, you may well have committed a felony. But have you committed an act of violence? Not unless it was a carjacking. And the courts have been saying, well, some of these people who've been convicted of non-violent felonies have never been convicted of an act of violence. This federal restriction on guns for felons as applied to them is unconstitutional. It's not generally unconstitutional, but as applied to non-violent felons, it's unconstitutional. So Carballo Flores decides this is fertile ground for him to appeal his own conviction for being an illegal alien in possession of a gun. He's going to challenge it both generally, the whole restriction should be unconstitutional under the Second Amendment, and as applied to him in his particular circumstances. The district court, meaning the trial court, declined his request to find the statute against illegals having guns unconstitutional. Applying Bruin's text and history framework, it concluded that the plain text of the Second Amendment presumptively secures for illegal aliens the right to possess firearms, but it held that the government rebutted the presumption by identifying a historical tradition of disarming untrustworthy adherents to the law, scofflaws, including British loyalists at the time of the founding. To the court, that tradition justified disarming illegal aliens today. So legal aliens might well have a Second Amendment right, but not illegal aliens, because there was a founding era tradition of disarming untrustworthy adherents to the law. Although the trial court rejected Carballo Flores's facial challenge, it found merit in his as-applied challenge, as applied to him in particular. Laws disarming British loyalists did not apply to those willing to pledge their loyalty to the American government. Once an individual disclaimed his loyalty to the British government, he was no longer considered dangerous or untrustworthy, and therefore could possess a firearm. From this historical exemption, the trial court reasoned that Congress may disarm only untrustworthy or dangerous illegal aliens. It concluded, the trial court did somehow, that Carballo Flores is a trustworthy adherent to the law, despite being an illegal alien, because, among other things, he is employed. Aren't we all supposed to be employed as adults? And has no felony convictions. Well, until this one. So as applied to him, the trial court decided Section 922 violated the Second Amendment. The government appeals. And the government can appeal because this is not an acquittal by a jury. This is a dispute over a matter of law. And that can be appealed even by the state. The government appeals. The Second Amendment secures the right of the people to keep and bear arms. Would have been helpful if they capitalized that, right? But of course, this is the whole Bill of Rights is in the context of political rights. The Supreme Court held in Heller that the right belongs to individuals. The Supreme Court has since confirmed that people's freedom to carry arms is not a second-class right. That's McDonald. It ranks instead among the most fundamental rights necessary to our system of ordered liberty. That's Rahimi. These are all seminal Second Amendment cases of our generation, at least my generation. The protections contained in the Second Amendment have their limits, though. And that's true. No constitutional right is unlimited. That, again, is from Heller, the first of these seminal Second Amendment cases. The government maintains some latitude to regulate who may possess firearms, what firearms they may possess, and where they may possess them. But like the constitutional right itself, the government's power to regulate also has limits. The Supreme Court in Bruin set out the now familiar test for evaluating whether a firearm restriction exceeds those limits. To begin, a court must interpret the Second Amendment's plain text. When the text covers an individual and his conduct, the Constitution presumptively offers protection, and then the burden shifts under Bruin. The burden shifts to the state to prove why that presumption has been rebutted. Continuing with the decision, the government may rebut that presumption by persuading the court that the regulatory burden is consistent with the nation's historical tradition of firearms regulation. This requires reasoning by analogy, which of course courts do all the time. A modern regulation with relevantly similar historical counterparts will survive the scrutiny. This does not demand identifying historical twins or dead ringers, an exact founding statute parallel to a modern statute. The government must only show that its modern regulation conforms to the principles that underpin that historical restriction. The courts rely on two metrics when assessing the strength of these analogies. We compare how the challenge regulation burdens the right to bear arms, and we consider whether the reasons, the why, is the same. So, for example, I mentioned earlier that there was a founding era law about how much gunpowder, a limit on how much gunpowder you could keep in your house. That wasn't considered a gun law. The why of that was not an arms limitation. The why was a fire hazard limitation. Nevertheless, that gunpowder law is cited by these rebellious, unelected, black-robed, tyrannical, inferior federal district trial courts who are anti-civil rights, anti-Second Amendment. They still cite that gunpowder limitation, which was a fire hazard limitation, as justification for limitations on magazine capacity today. Obvious nonsense.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.